Hello, everyone, and welcome back to This is a Woman podcast. I'm your host, Sophia Lorey, and it has been a while since we've done a podcast, but today there's not a guest. We're going to dive into what happened at the Supreme Court literally this morning and what all of that means. I know there's a lot going on out there. People are thinking, so does that mean boys are no longer in girls' sports anywhere? Are girls' sports completely protected? What does this mean? What was the vote? Why am I hearing that some of the vote was 6-3 and some of it was 9-0 from the Supreme Court? We're going to dive into all of that. We're going to actually run through too. I have literally all of the opinions completely printed out. It's 77 pages. I read through all of the opinions, those in support and those dissenting. We're going to just dive through all of that, break it down, so maybe you guys watched the podcast episode a little while back, and if you didn't, you can go watch after this, but it was about the Supreme Court hearings. We really dove into the two girls' sports cases, which was West Virginia v. BPJ and Little v. Hecox. These were the two Save Girls Sports cases that were heard back in January. And so if you don't know, that's how the Supreme Court works. We have oral arguments, and then months later, we tend to get to the decision. And today was actually the last day for the Supreme Court to drop their decisions. And it's not unusual that this case was dropped at the last day. They did the same thing for Dobbs, which overturned Roe v. Wade. They normally hear at the very end, and they announce all of their more controversial opinions at the very end, due to the fact that then they can go home for summer, get out of the Supreme Court, safety reasons, all of that. So it was not too big of a shock that we waited until the last day possible to get the two Save Girls Sports cases. So let's dive into it. I just want to make it very clear from the beginning, what did the Supreme Court rule? What were they ruling on? And so the Supreme Court was basically answering the question, do states have the right to protect girls' sports? Yes or no? It wasn't saying they didn't have to decide either states have to or they can't. It was just, do they have the right? Which is also a little disturbing, I would say, if you think about it. We're here in 2026, and the Supreme Court, the highest court of the land, is literally deciding whether or not states can or cannot protect girls' sports. Like, it just so mind-boggling that this is where we're here in culture and society, but I am very grateful that the Supreme Court took up this case. And so we had a great ruling today that the Supreme Court decided that states do have the right to protect girls' sports. So right now there's 27 states that have laws in place protecting girls' sports. 23, unfortunately, don't. I know all the listeners are from a bunch of different states. I'm based in California, and we are unfortunately one of the states that don't protect girls' sports. So that means nothing changed necessarily for California or the other 22 states that don't already protect girls' sports. And if you're wondering, does my state protect girls' sports? Does it not? You can look that up online real easily, as well as at familypolicyalliance.org. They actually have a map and will tell you which states do and which states don't and what the state laws are. But what this means for the states that don't protect it, so as someone in California, this now gives us the ability to tell our governor, our legislature, and CIF, which is who oversees high school sports in California, that you do have the right to protect girls' sports. Why won't you? Why aren't you? Why are you not standing up for the girls in your state, our daughters? And for the other states, those girls are now safe. They have those protections. Those laws were already in place, but it just is a double down of the Supreme Court being able to say, yes, states, you were right. You do have those rights. And so what they were looking at in both of these cases was Title IX and the Equal Protection Clause. Many of you probably know what Title IX is, or it's the more familiar one that people know about. And so I just want to read to you guys what Title IX actually states. And so Title IX states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's what Title IX is. It's simple. It's literally one sentence. And it was a federal civil rights law that was passed in 1972. So this was really what opened up the door for girls' sports. Because at that time, we saw, even like at colleges and schools, there was just a lot more opportunities for boys and boys' sports, better resources, more teams. And so Title IX really came in and is what launched girls and women's sports to be what they are today. The other thing that the court was looking at was equal protection clause. And the equal protection clause, it's a core provision of Section 1 of the 14th Amendment to the U.S. Constitution. And this was put into place in 1868. And so basically it mandates that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so that might be like, what does that really mean? We're going to dive into like way more in depth of what the equal protection clause means as we're going through just what we heard from the court today. But you may have seen some people saying it was a 9-0 ruling, and other people are saying it's a 6-3 ruling. And what does that mean? And what's going on? And so here's what happened. The court held 9-0 that under Title IX, the girls' sports cases that came out of West Virginia, Idaho, that they can protect girls' sports, that states can restrict males from being girls' sports. So all of the justices on the court did say under Title IX, yes, girls have that protection. States have the right to protect them. And some people might be thinking, well, that's crazy that all 9 Supreme Court justices agreed on this. But I think this really shows that is what the Supreme Court was made for. Even though we know that there's very conservative justices on it, very liberal justices on it, they are not there to put in their opinion. They're not there. You hear more of their opinion in their written opinions, but they are not there to rule based on their opinion. They are there to rule based on the court of law. And so this, I think, does show well that they were able to rule correctly based off of what the law actually says and push opinions aside. There is a lot of opinions, though, and some crazy ones. So we will get into that. But then we saw for the equal protection clause, that's where the 6-3 ruling was put into place. And so that's where there was some debate in that ruling. Again, we'll dive into that. But so you guys know who ruled, again, 9-0 one way, but for the 6-3, who ruled in favor of allowing states to protect girls' sports with the equal protection clause was Justices Kavanaugh, Thomas, Gorsuch, Barrett, Alito, and Roberts. Those are the 6 justices that I believe ruled correctly based off of what the law is. Then we have the dissent from Sotomayor, Jackson, and Kagan. And so it's kind of interesting as we dive into this that it's 3 of the female justices. There's 4 female justices. 3 of them are the ones that had the dissent, and they kind of get in a lot into transgender ideology and erasing women. So that really is disturbing to see. But let's just kind of dive into it. So we have, when the Supreme Court releases their decisions, delivers the opinion. So for this one, we had Kavanaugh. He delivered the main opinion. Then we actually also got concurring opinions from Thomas and Gorsuch. So they always have a main person that delivers the opinion. But if someone else wants to add something in, so that's why we see that as well. And then we actually have Sotomayor. She's who delivered the main dissent, but they also had a little bit where they put in their concurring opinions because, again, they all agreed on the Title IX section. So there is a lot to go through, but when they drop it, we get the whole thing. So it always starts off with like you have the syllabus, it breaks down it, then you get into all of the concurring and opinions and dissent. And so again, it starts off right when we get the syllabus from the Supreme Court where it states what I told you guys. The question before the court in these cases is whether under Title IX and the Equal Protection Clause of the 14th Amendment, schools may maintain women's and girls' sports teams for biological females, i.e., may schools determine eligibility for female sports based on biological sex? And I also want to make clear, I am very pro. We don't say biological male and female, that there's just male and then there's just female. But if you guys hear me saying that, it's because I'm reading word for word what the ruling actually says. And so I'm just going based off what they said. But that was the main question. And now let's get into the opinion of the court, again, delivered by Justice Kavanaugh, who I think did a great job. in his delivering. And so again, he really kicks off with explaining Title IX, how it's been in place for 54 years and what Title IX has done. And so literally paragraph 2 of his very long opinion says that this is to provide equal opportunity for female athletes. Schools do not merely maintain, for example, one soccer team, one basketball team, one ice hockey team, and one lacrosse team that are equally open to female and male athletes. That approach would deny equal opportunity to female athletes because, as all agree, females and males have inherent physical differences relevant to athletic performance. And so again, that's just really clarifying. That's why Title IX was put into place. That's why there is multiple sports teams. You have a male team, male soccer team, a female soccer team. So that way no sex is denied equal opportunity. But my favorite part was right when this came out, it comes out and you're reading through it. What did they say? There's so many good one-liners and different things. But Justice Kavanaugh, he said, he goes through, he's explaining a lot, and I love how simple he puts it. In other words, may schools determine eligibility for women's and girls' sports based on biological sex? The answer is yes. And so it's so simple, so straight to the point. And yeah, I love that this is how the ruling went. It just, okay, yes, the answer is yes, that's what it is. And so then we hear him dive into, because that was more also that answer was on the Equal Protection Clause. Then he says the same thing about Title IX. The question is whether Title IX permits schools to maintain women's and girls' sports for biological females. The answer is yes. And so we did truly believe this is how the ruling was going to go based off of the oral arguments back in January, what we heard inside the court, what we were all talking about outside the court. We did believe it was going to go this way. We just, of course, didn't know necessarily what the opinions would state. And so another great explanation from Kavanaugh, he states, moreover, BPJ, and so BPJ is the male athlete that's in the BPJ versus West Virginia case. It says, moreover, BPJ might not want to compete against boys. Either way, it is an unhappy occasion whenever a student who wants to play school sports cannot do so. We appreciate the desire of every student, including BPJ, who wants to play school sports. And we recognize that student athletes are understandably disappointed and upset when they do not make a team or otherwise cannot participate. But the Title IX regulations guarantee equal athletic opportunity. The regulations cannot and do not guarantee every student a spot on a team's roster. And I'm so glad that got brought up, because there is a certain age when it comes to sports when your kids are 5 and they're 6 and they're 7 and you're putting them in all the different rec league sports in your city and you're just trying to get them to go outside to figure out what they like. But it hits a point with sports where it's less about, I just want to find the sport I like, and this is competitive. This is a competition. I'm looking to go play college. I'm looking to make the varsity team at high school, whatever it is. And so I like that they point out that Title IX guarantees equal athletic opportunity, but it doesn't guarantee every student a spot on a team roster. You might not make the team if you're not good enough. And so I just love how Kavanaugh puts it. BPJ, male athletes, might not want to compete against boys, and it's unhappy when you can't play in certain things, but that's the reality of sports. You might not make the team. You might not make things. And so we cannot ignore what is already in law just to make everyone happy. And it's like, I don't know, I think it's kind of going back to like the everyone gets a trophy thing. But I love the way too, and I know I keep telling you guys, I love the way they're answering things. Trust me, you're going to hear a lot of things from the dissenting opinions that I do not like. So let's just soak in the positivity right now. But he then puts, for the opinion of the court, in sum, Title IX allows schools to provide separate women's and men's sports teams defined by biological sex. Consistent with Title IX, West Virginia has permissibly maintained women and girls sports for biological females. So just a lot of emphasis on what they're doing is correct for women's sports. And then something about Justice Kavanaugh, he is actually a basketball coach for a girls team. And so I just thought this paragraph of his was funny and relatable because I played sports, I played soccer, but it says the safety risks are at their apex in contact sports, such as soccer, basketball, field hockey, lacrosse, ice hockey, among others. Anyone who thinks that those women's and girls' sports and other sports like them are not contact sports has not witnessed a game recently. And I just thought that was so funny because he's right. If someone's trying to say, well, it's not a safety issue. Girl sports aren't as aggressive and things like that. I just felt like that paragraph from Kavanaugh, his coaching side of like actually watching girls play comes out because, yeah, if you watch, and I'm just going to relate it to soccer again because I played soccer. If you watch women's soccer versus men's soccer is a lot faster pace. They're moving the ball in a completely different way. Women's soccer is a lot more aggressive. So I thought it was funny that he basically said, if you don't agree with that, you just haven't watched women's sports in a long time. But his opinion continues on, and like we literally could spend hours going through word by word, but I just wanted to pick out the different highlights for you guys out of his case. But I want to move on to now, again, like I said, they can write their concurring opinions, which are significantly shorter, but we have Gorsuch's concurring opinion. And his is only 3 to 5 pages long. And his dives into just a bunch of different past Supreme Court cases, which the Supreme Court does often. They will use past Supreme Court cases to help with their opinions and their rulings on current Supreme Court cases, which is why it's always so important that they rule correctly based off of the law. But his, like I said, dives into other court cases. But again, I just want to emphasize, he wraps his up with saying, but as there, our charge here isn't to resolve those debates, only to apply faithfully directives found in a federal statute. And as in Bostock, I believe the court does that job today, reaching the result the law demands. So Bostock was another Supreme Court case that they've seen in the past. And again, he lays it out there. As a Supreme Court justice, their role is not to resolve necessarily all the debates about different things. It's just to apply faithfully the directives found in a federal statute. They're just supposed to make sure things are done based off of the law. And so now to my favorite concurring opinion by Justice Thomas. What a nation this place would be if all of the justices were just like Justice Thomas. He's my favorite justice. And his opinion is literally 2 pages. It's short, straight to the point. It's so great. But I love this line because he says what we're all thinking, what we've all been thinking this whole time. So Supreme Court Justice Thomas says, a man does not have a legal right to compete against women just because he believes that he is a woman. And it's like, bingo, this is what we've been saying the whole time. Identities don't play sports, bodies do. Just because you think you're a woman doesn't mean you're a woman, doesn't believe that you have the legal right to compete against women. I mean, that's so common sense. You could think you're an octopus, you could think you're an action figure, whatever you think you are doesn't give you then like the right to compete in these different things. Like it's so straight to the point and so plain, but that was even his best line. His next line, and I've been seeing this all over social media because it's so good. Justice Thomas says, men and boys with gender dysphoria are not women or girls, even if they believe that they are. Sex is an immutable biological characteristic. Like, if they put out this whole ruling and that's all they said, it'd be like mic drop, so great. But he's right. Even if you have gender dysphoria, you are still not the opposite sex. Even if you believe you are. It's like when your 4-year-old's playing pirate and they say they're like a pirate and they want an eye patch, are you gonna like gouge out their eye or to give them an eye patch? Like, if they want a stick leg, like if your 4-year-old thinks they're a pirate, you're not going to gouge their eye out and cut off their leg and give them a stick leg and buy a parrot for their shoulder. So just because you think something doesn't mean it's the case. And I love that he just says sex is an immutable biological characteristic. And lastly, one of his last lines that I think everyone could really take just maybe a little conviction from on how to live our lives. But he says, because a lot of this is a language issue of people saying, well, this transgender, this, that, this biological, this. No, it's male and female. We need to just call it as it is. We can't be saying, oh, this transgender female athlete, like, because then you're like literally playing a mind game trying to figure out what people are actually saying. It's a male athlete in girls sports. We can't change our language. That's what kind of got us here, is we were okay with people changing language and what things actually mean for such a long time. And so Justice Thomas, his final line in his concurring opinion, to use language to obscure reality, to show indifference regarding the truth, is to lie to the public and cease to treat our fellow citizens as equals, which is just so good. He's right. We shouldn't be lying to the public. We shouldn't be changing the language to show indifference regarding truth. We shouldn't have any indifference regarding truth. We should be standing for the truth. We should be saying what's right. We got here because of people being afraid to say what is true and what is right. So those were the opinions and the two concurring opinions. Barrett and Alito and Roberts, again, all also voted on the 6-3 in favor, had great votes there. No one has to write extra opinions. That's up to them if they want to do so. So now we're to the dissent. And I just want to make clear again, Sotomayor, Jackson, and Kagan, the three women who dissented, they did not dissent to the Title IX. They dissented to the Equal Protection Clause. And so we have a lot from them on this. And it's really honestly interesting, the arguments they have to say, but we're going to dive through it. And I think it's important for people to hear how illogical some of these thoughts are. And it's a little scary that justices that are on the highest court of the land could think this way, but let's dive right into it. So Justices Sotomayor, she wrote the main dissent. And literally her first line is, respondent BPJ is a transgender girl who wants to live her life consistent with her gender identity. It just, it starts off already so ridiculous. But I want to make one thing clear for the Christian listeners right now. Genesis 1:27 is so clear. God made us male and female. There's no confusion. God did not make a mistake in the way that he made us. And so the best thing we can do for these confused boys and girls who think that they're the opposite sex or that they were born in the wrong body is to tell them the truth, is to not lie to them, is to make sure they know that God made no mistake in how he made them. And the best thing we can do for their mental health is also tell them the truth and try to figure out, why are they struggling with their sex? Why are they buying into these lies? And so it just comes across that Sotomayor just thought she was really doing something great. BPJ is a transgender girl who wants to live her life consistent with her gender identity. Almost like, this is all this little girl wants. Why don't we just let her? Even though the most harmful thing we can do to this boy is let him think that he's a little girl and that this gender identity is a real thing. It's just not. And so Sotomayor kicked it off strong. And where you can see here, I wanted you guys to see where, even though it's a dissent, there's some concurring opinions, because again, 9-0 on Title IX. So Sotomayor did say, I agree that BPJ's Title IX claim fails, although on a narrower basis than that on which the majority relies. So right there, Sotomayor is basically saying that she agrees with them. His Title IX claim fails, yet not to the extreme or to the extent that the opinion from Kavanaugh and all of those who agreed with him had to say. And then we again see from Sotomayor, BPJ is also transgender. Her sex was identified as male at birth, but she has known from the time that she was very little that she is a girl. There is no such thing as you weren't identified as a male at birth or as a female at birth. You are a male or a female. That's how we're literally able to figure out the sex of a baby before it's born. It's not like the baby comes out and the doctor's like, we're identifying it as this. No, that's why a mom can when she's pregnant, go get a blood test to figure out if the baby inside her is a male or a female, because these are things that cannot be changed, that are just factual. And it's really sad but she has known from the time that she was very little that she is a girl, and just the lies that this young boy has bought into, that the parents have obviously affirmed, and who knows if they're even the ones that have kind of started this idea. That's what we see a lot of times today, is these parents are pushing these ideologies, or these kids are learning it from school. And I think if any child at a very young age goes up to someone and tells them that they feel like they're a girl but they're a boy, or vice versa, we shouldn't just say yes, 5-year-old, you're right. When your 5-year-old is constantly wanting to have donuts and candy for breakfast, you don't just say, well, if that's what you want and that's what you feel like. No, you explain to them, this gives you tummy aches, this isn't good for you, you can't be eating stuff like this, we have to have a good breakfast so you can grow. And you don't just say, well, if that's what you feel like, and go with what the child says. And Then Sotomayor also is explaining this whole thing that the male athlete's mom basically said that if we don't allow boys to play with girls' sports, it could quote unquote erase her, which when we are continuing to allow males into female spaces and pretend that males can be females and females can be males, and that males get to be in girls' sports and pretend to be girls and wear makeup and do all the things, that's erasing females. That's not erasing these confused boys. It's erasing females and what it really means to be a female. But one of the other points I really just wanted to hit with you guys is Sotomayor says that because of the medical treatment that BPJ has received, she has never experienced a traditional male puberty and so has never experienced elevated levels of circulating testosterone. BPJ contends that as a result, she does not have an inherent athletic advantage due to her sex identified at birth, and accordingly, that her participation in girls' sports does not threaten competitive fairness or safety. Maybe some of you guys are hearing that and you're thinking, oh, well, if this boy had his male puberty blocked at a young age and never went through a traditional male puberty, maybe he can play with the girls because maybe he's not as strong as the girls because he didn't go through that. Because we do see a lot of changes in male athletes from when they're 8 years old to they're 12, 13, 14 years old. We see those changes because of puberty. But I just want to dive into some facts with you guys. And if you're watching, you'll be able to see this on the screen. But if you're just listening in, there are multiple things biologically about a male and female that what's different about a male body cannot be eliminated just because puberty was blocked and cross-sex hormones are started. So what does that include? It includes the speed of a male. Okay, even if a male had his puberty blocked and delayed and then went on to cross-sex hormones, male and female's bodies, bones are biologically different. So for a male, they have a narrower pelvis and a less angled femur, which places less resistance on a man's knees and lower body, literally allowing him to run and pedal faster than female athletes can. So the angle of a woman's femur is 16 degrees. The angle of a man's femur is 12 degrees. And we see these different body types, even just for reproducing children and things as such. But this makes it so that no matter how much puberty blockers and cross-sex hormones a male has, our body's bone structure is still different. And then we can talk about endurance. So a female heart is only 2/3 the size of a male's, so it cannot pump as much oxygen-rich blood per beat to working muscles, which means as well, a woman's lungs are normally about 12% smaller and process less oxygen per breath. So a male has the ability to take in and use oxygen at an aerobic capacity up to 25% greater than a woman's, which gives so much of an advantage when it comes to endurance. And then lastly, strength. When it comes to muscles, the fibers in male muscles are thicker and more densely packed, which increases things when it comes to lifting or even just jumping and sprinting. I mean, I know from soccer when we would train to be better runners and sprint, it did do a lot with weightlifting and building up that muscle mass. And so the way the muscle fibers are, the way a heart and lungs are, and our femurs and the angles of them, that cannot be changed with cross-sex hormones. And so that just completely eradicates Sotomayor's argument there. And then again, she states the similar thing. She says transgender girls who have never experienced an endogenous male puberty, who receive gender affirming treatment, and who are, she says, the similarly situated to cisgender girls. And again, everything I just said completely disproves that. But I believe that is all we're going to dive into in Sotomayor's for the rest of that until the very end. So the very end, Sotomayor says the majority's opinion ends by reciting the many wonderful ways in which playing sports can be valuable to young people. It can help build resilience, tenacity, leadership, and discipline. It can lead to lifelong friendships, community, and a sense of belonging. It can bring joy and the thrill of victory, along with all the lessons one learns from experiencing defeat. The benefits are immense. Because of the court's decision today, West Virginia and any other state actor can deny BPJ and others like her these experiences simply because it thinks they have an inherent athletic advantage, even if the facts show that they do not. In the end, to the court, the facts do not matter, even though the consequences are serious. The ban is absolute, so BPJ cannot practice on girls' teams, even if she would not take anyone's spot in an eventual competition, even if everyone who tries out for the team makes it, and even if having the chance to participate could aid in immensely treating BPJ's gender dysphoria. Sports, of course, are often zero sum, but the law need not and should not be. Because the court today errs by reducing the burden, at least in the sports context, that the Constitution places on state actors when classifying based on sex, I respectfully dissent. And oh my gosh, I have so many thoughts just on those two paragraphs alone. So Sotomayor is like, yeah, let's list out, just like they did in the concurring opinion, everything good that sports can bring you, right? So why are we going to take that away from girls? There's girls that have quit playing sports because of the issue of males and female athletics. There's girls who have been cut from a team because of males on it. And so we just list out all of these great things, and then we say, the feelings of a confused male should then pretend to be a girl and be able to take away those opportunities from females. That's just not right. And literally, I wanted to laugh as I was reading this to you guys. And when I read it for the first time, when Sotomayor said, in the end, to the court, the facts do not matter. Like, everything I read you from her is so illogical and so not with facts. Males cannot be females. Females cannot be males. That cannot happen. So it's just really ironic that she thinks that to the concurring opinions and Justice Kavanaugh and all those justices that the facts don't matter to them. So that's just a little silly to me, but I promise we're almost done here, guys. We're going to go through now. We have from Justice Jackson, the concurring, and she does the concurring with the judgment of Title IX, the dissenting, and part of the Equal Protection Clause. Sotomayor was the main one, which was why hers was so long. But with Jackson's, I want to just talk about a couple of things. So Jackson, when she is talking about Title IX, she is basically talking about how the court shouldn't have assumed when Title IX talks about sex that it means biological sex. So Justice Jackson states, instead, the court should have assumed as much while leaving open the possibility that Title IX's definition of sex is more capacious. As the majority notes, BPJ does not argue that sex in Title IX means anything but biological sex, and that sex is assigned at birth. So I want you guys to really think about what she's saying here, that when it comes to Title IX, why are we assuming that their definition of sex when they wrote Title IX just meant biological sex? What about sex assigned at birth, which we already talked about how that's not even a thing? This Title IX was written in 1972. Do you guys think anyone in 1972 was even thinking about these things? No, because this just recently started blowing up. People were not bought into this transgender ideology in 1972. And so for her to say, who knows, what if they meant all these things? I believe the reason that they didn't necessarily define sex back in 1972 was because in 1972, everyone knew what a male and a female was. Not because it was an open door to these things, but if you went back, like if you're listening right now and you were alive in 1972, think about this. But if you weren't, if you go back to 1972 and told people, hey, as you're writing Title IX, let's define male and female, because one day there's going to be a lot of people that are super confused, and we're going to have Supreme Court justices that cannot define what a woman is, and they're going to claim it's because they're not a biologist, and we're going to have people that get that confused. People would probably look at you like you were insane or laugh in your face. And so it's just so ridiculous. That is the angle taken. And then one of the other things I wanted to walk you guys through with what Jackson said is that BPJ suffers discrimination on the basis of sex. Yes, sex assigned at birth. When she is excluded from the girls' team because she was assigned male at birth, change her sex assigned at birth to female, and her ability to play girls' sports changes too. So right now, Jackson, who is a woman, and is now working towards the erasure of womanhood based on what she's saying here, Jackson is quite literally stating that a male who wants to play in girls' sports and thinks that they're a girl suffers also discrimination on sex because of the sex they were assigned at birth. So who's discriminatory now? The doctor that confirmed that this was a male because everything proves that's a male because you're either male or you're female. So that is how some of these Supreme Court justices are thinking, which is why we have to stand for the truth, why we can't just let our words and language be changed to mean whatever people want it to mean, whatever culture says it means at the time. We have to stand for the truth. And so I know that kind of ended maybe like on a more little negative note because the dissent is a little insane, but today's ruling is an extremely positive ruling. It is a step in the right direction. It is not the end. It is not the end of boys and girls sports. As I said earlier, they've ruled that states do have the right to protect girls sports if they would like to use it. We have a lot more work to do in California and the 22 other states that are not protected yet. So we celebrate today. We take this win. I think it's so encouraging to see the highest court of the land is ruling correctly on the protection of girls' sports. But we have to keep fighting. We have to keep standing. This issue is nowhere over. And so, go back, go listen to some of the old episodes where I had different attorneys on, where we talked about the oral arguments right when it happened. We dove more into what the cases are. But I know it can be overwhelming to hear what people are saying about the Supreme Court, trying to understand why is there so many different opinions coming from justices? What do the numbers mean? What does the ruling mean? So I'm hoping that all just broke it down for you guys so you guys can understand. And if you guys want to read the entire 77 pages of opinions and dissents in the syllabus, that will be linked in the show notes. So feel free to read that. But what I brought to you guys were some of the main points, some of the most important one-liners we had, good lines we had, bad lines we had. But the fight's not over. We must continue to stand for protecting girls' sports and the states that's not protected yet. One way you guys can help do that is you guys can go to xxonly.org. You can sign the petition urging CIF to protect girls' sports and to follow Title IX. Yes, CIF is California-based, but you can live anywhere to sign it because I do believe as California goes, so does the nation. So you guys can sign it no matter what state or country you live in and no matter how old you are. This isn't something where you have to be registered to vote or over 18. And so you just fill it out online. Let's get your name added to that. Let's keep the pressure on California and all the other states. But I truly believe if we can get California to change on this, we will watch the rest of the states that haven't yet follow along. So that is it. Share the podcast with a friend, with a family member. And I just again want to emphasize girls' sports are not 100% protected yet. If people start to think that, we're going to lose momentum. We need to take this. We need to let today's win light a fire underneath us and keep the momentum going to keep saving girls' sports. But with that, I will see you guys all next time.